again, she could prove at trial that she was sexually assaulted. And your argument is, but Mr. Olson would be able to say, but you violated the non-disparagement clause by proving, in this case, at trial, that you were sexually assaulted. So I also get damages for you having truthfully litigated the sexual assault. Do I misunderstand the argument?
Calling our second case on our morning calendar, Jane Doe versus Curtis Olson. And for this case, we welcome the Honorable Carl H. Moore, Associate Justice, Court of Appeal, 2nd Appellate District, Division 5. When you're ready, counsel.
Thank you, Madam Chief Justice, and may it please the Court. Jean-Claude Andre on behalf of Jane Doe. We're here because my client, Jane Doe, alleges that she was sexually assaulted and harassed. She then sought a civil harassment restraining order based on that conduct. That restraining order proceeding resulted in a mediated stay-away agreement between the two parties, Ms. Doe and Appellant Olson. And that stay-away agreement had a non-disparagement clause. She then sued for damages in unlimited civil court. And she's allowed to pursue that suit without worrying about the chilling effect of a derivative breach of contract suit saying that she breached the non-disparagement clause. Whichever way this court looks at it, whether through the prism of the litigation privilege, which is an absolute defense, or whether it looks at the issue through the lens of basic contract interpretation principles, her suit is not barred and it should not be impinged or otherwise maligned by a derivative breach of contract suit like the counterclaims that Mr. Olson brought. As a result, the Court of Appeals decision must be reversed, and if the court will permit me, I'd like to start with litigation privilege. The litigation privilege writ large dates back over 500 years in England to the era of the Queen's divided bench. This state's legislature codified it in the late 1800s, and ever since 1964 and Justice Trainor's opinion in Albertson, this court has given it an expansive reach. In 1990 in Silva, this court effectively articulated the 4 elements of a litigation privilege defense. Those elements are that the communication was made in judicial or quasi-judicial proceedings, by litigants or other participants authorized by law, to achieve the objects of the litigation, and that those statements have some connection or logical relation to the action. As a result of those broad elements, as stated by the court in Silberg, this court repeatedly, whether you count the 3 to 5 direct litigation privilege precedents from this court, or look to other related areas like the anti-SLAPP statute and malicious prosecution doctrine, where this court has said overall, time and time again, that the litigation privilege is there to vindicate the vital public policy of free access to the courts. As a result, this court has said that the litigation privilege applies not just to virtually all torts, but to virtually all causes of action, and that its reach is expansive. Now, our position here, that the litigation privilege should apply to bar Olson's derivative counterclaim for breach of contract, actually rests very comfortably with all the published precedents of the courts of appeal. In fact, it is Mr. Olson's position that would require this court to overrule at least 3, if not 5, of the published decisions of the Court of Appeal, and instead our position allows this court to navigate through that precedent and articulate a rule that can be applied with the only decision being overruled being the one by the lower court in this case. And in particular, our rule is that the litigation privilege may apply. This goes directly to the first question noticed by the court. The litigation privilege may apply to breach of contract claims unless there is a clear and explicit waiver of the privilege and that waiver is consistent with public policy. At this point, I guess I'd like to go through the various courts of appeals decisions that I think this court would have to navigate or potentially overrule, depending upon which way the court goes. Most on point is the Court of Appeals decision in Vivian. In Vivian, there was a non-disparagement clause just like the one at issue here, except that it had a little bit more specificity. That particular clause had a carve-out for disparaging statements made in family court, because that non-disparagement clause and that settlement agreement arose also out of a restraining order proceeding and related to divorce. And in that case, even though the counter-defendant made disparaging statements about her ex-husband to internal affairs investigators from the sheriff's department, the Court of Appeals said those communications were privileged because the non-disparagement clause in the resulting restraining order agreement was insufficiently specific to bar those statements. There was not a clear and explicit waiver of the counter-defendant's right to make her statements. Similarly, there's the decision in Feldman where there's an apartment complex that filed an unlawful detainer action, and the renters cross-complained for breach. The First District found that the litigation privilege applied because the rental agreement did not have a clear waiver, and barring the claim would actually reduce litigation. The third case on which we rely from the Court of Appeal is McNair. That was an employment contract, which had that had a confidentiality provision, and a health investigator from the city of San Francisco went to the DMV and said, I think this bus driver is unfit to be a bus driver. And there again, the Court of Appeals said that the litigation privilege immunized those statements because the waiver, or the confidentiality provision, was insufficiently express to waive the speaker's right to go to the DMV and report what the speaker thought needed to report it. Moreover, yes.
So you began your presentation by laying out two potential paths to resolving this case, one that rests on contract interpretation. I guess I'm wondering, given your description of what the litigation privilege analysis looks like, whether there isn't some significant overlap between those two things. The first step of the litigation privilege framework, as you've outlined it, seems at the end of the day to be a step that turns entirely on a rule of contract interpretation, which is a rule that says we will give effect to clearly expressed waivers of the litigation privilege, but not otherwise. Does that seem like a fair encapsulation of the argument, or is there a refinement that you would make to that position?
Both, Justice Kruger, if I may. I mean, the refinement would be that if this court wanted to go so far as to say that the litigation privilege can apply writ large to breach of contract claims, then it would fully be an independent basis for reversing the Court of Appeals decision. But you are also correct that there's significant overlap between our two positions here, or the two paths that we've charted for the court. Because yes, under our reading of the body of Court of Appeal precedent and the body of out-of-state precedent, that ultimately, because the litigation privilege was originally designed to apply to defamation, and then it was expanded to all these other torts, and then again, more recently in the lower courts, but not by this court yet, has it been applied to breach of contract cases, we believe that the kind of fair minimalist reading is to say, well, fine, it can apply to some breach of contract counterclaims, and it will apply to ones except where there is a clear and explicit waiver. So to get back to your question at the outset, yes, I think there's significant overlap between the two issues, or between the two paths.
But could you crystallize for me what the difference between those two analytical paths would be?
I mean, I guess I don't really think there is one. That's why I was saying that it, writ large, if this court were to hold that the litigation privilege just blanketly applies to breach of contract claims and extend it that far. In other words, there is a statement in this court's decision in Action Apartment that the litigation privilege applies to all claims except for malicious prosecution claims. Now, Action Apartment wasn't a straight application of the litigation privilege, so arguably that statement's dicta. But if this court were to embrace that statement from Action Apartment in this case, then that would be an independent path. But otherwise, I agree with you. I would concede that the two paths overlap significantly, because in order for the litigation privilege to apply to a derivative breach of contract claim, we would have to have a situation like this. And I think this will be the situation in most cases, at least certainly ones coming out of the restraining order context, where there is not going to be an explicit waiver of the initial plaintiffs' litigation rights, because those proceedings are just not designed to address the situation. Unlike employment contracts or sophisticated contracts between two businesses, perhaps dealing with trade secrets, which brings me to the other case, or the other cases, and in particular the case on which Mr. Olson in the Court of Appeal relied, the Wentland decision. I'm still a little bit confused as to how the Court of Appeal split the baby the way it did here in finding that Ms. Doe's administrative claims were privileged, but her civil action was not. In finding that her civil action was not privileged, the court pointed to Wentland. And Wentland is just so far afield from this case. In Wentland, it was a dispute between a number of partners in a property management company. And the partners were pointing fingers at each other saying, you're mismanaging or you're not being fair. And ultimately, they decided to settle their grievances by one partner selling their shares to the other. Then the resulting settlement agreement had a very specific non-disparagement clause. It said, you shall not make any statements about me and my potential mismanagement of the partnership before I sold you my shares. And on top of that, there also was essentially an embargoed letter of apology that if there was a breach could be marched out. And that letter of apology effectively resolved the truth of the dispute between the parties, who really was mismanaging the partnership and who was not. None of those features are present in this case. And so again, if the court is looking to kind of draw a line, in Wentland, you had sophisticated parties represented by counsel, valuable consideration, a clear and explicit waiver of the litigation privilege because it was specific and it talked specifically about the issue of mismanagement of this partnership, and you had a resolution of the truth of what really happened by virtue of this letter of apology. And that is just nothing like what we have here. What we had here is Ms. Doe went in 2015 and sought a civil harassment restraining order. The court ushered the parties into a mediation program, which is, at least at the time, was standard fare in the Santa Monica courthouse of LA County Superior Court. The parties go in there, and there's a volunteer yet court-appointed mediator who tries to lower the temperature and get the parties to agree to maintain the peace. The result of those proceedings, or that mediation, was the agreement that the court has before it. It's written out by hand. It was written out by the mediator because he ran out of the typewritten form. But basically, it captured what the typewritten form would have said anyways, and has various things that you would expect from a civil harassment or workplace or domestic violence restraining order proceeding. It says the parties shall stay away from each other, cross the street if you see each other. You shall not disparage one another. And that's it. It doesn't go into any specificity about which side is telling the truth. There's no release of claims. There's no, for example, 1542 release, as we've seen in other cases. It's just a generic non-disparagement agreement. And so in this case...
Can I ask you about this? With the non-disparagement language in this particular one-off agreement, there's a suggestion in the papers that it does differ from the standard language used in such mediation, which is more specific in general about what the intended scope of non-disparagement is. So there's a suggestion that usually these mediation agreements distinguish clearly between disparagement to third parties, the parties might run into on the street versus reporting claims to authorities or pursuing remedies in court. Is that your understanding as well, that this is a difference between this one-off agreement and typically used in these types of situations?
No. I must strongly disagree. This agreement was a one-off only insofar as it wasn't the typewritten, pre-printed form, but the mediator who'd conducted, I don't know how many dozens, perhaps hundreds of these mediations, knows what all 6 items are to be listed and just scratched up by hand. What makes it a one-off is that it wasn't typewritten and pre-printed, but the substance for a civil harassment restraining order mediation agreement is right down the center. It comports with all the typical agreements. And in fact, the amicus brief submitted by the mediator amici explains that. We were fortunate to have the support of 2 of the leading Southern California civil harassment restraining order mediators. They train new wannabe mediators on best practices for conducting these mediations. And as they've told us and told the court, this particular mediation agreement is very, very standard fare. And if I could go to other features of it, I think they'll help perhaps answer more of your question, Justice Kruger. If you look at the sum total of the documents that were before Mr. Olson and Ms. Doe when they went into the mediation, there's an informational form, CHN, I want to say 110, maybe there's two, CHN 100 and CHN 110. And those forms explicitly say that if you want to seek money, you have to file a civil suit. They also carve out of what interpersonal contact you can have by saying, the lawful, peaceful service of process is okay. And so when you read that together with the stay away component, it means, okay, yeah, cross the street if you see each other, but if you're going to peacefully serve someone, that's okay. In addition, the actual agreement signed by the parties contemplates other civil proceedings because it says that the evidence that is introduced during this mediation may be used in other civil proceedings. That, of course, also comports with the statute, 527.6W, which contemplates additional civil proceedings. So whether you're looking at the actual four corners of the agreement here, whether you're looking at the overall statutory scheme, whether you're looking at what the mediator amici have told you, by all accounts, this mediation was a very limited proceeding designed to get the parties to agree to basically just behave, right? And, don't disparage each other, meaning don't say bad things about each other, in the condo complex where Olson and Doe were neighbors. Don't say things to, the media. But it doesn't extinguish the fundamental right to petition the courts for redress. And in fact, again, the agreement itself in the overall context contemplates that Ms. Doe, after obtaining the immediate peace and security from this mediated agreement, would have to seek any damages that she wanted to seek in a separate civil proceeding. And that's what she did. And, Mr. Olson has come back and said, well, we're not saying that her suit is barred. What we're saying is that, no, we can basically proceed in parallel, and we can try to impose a penalty of civil damages, breach of contract damages, if Doe shoots and misses. And, our position is that that's not the orderly way of resolving civil disputes. This court has said, and I guess the lead case here is this court's decision in Rubin, that it prefers for the original litigation to resolve disputes between the parties, regardless of who initiates it. And then, once that original litigation is resolved, the remedy that, if it's a defendant, the prevailing defendant may pursue is malicious prosecution. It is not to have suits in parallel, and that is exactly what Mr. Olson is doing. He is trying to proceed with this breach of contract penalty of damages suit in parallel, along with Ms. Doe's initial suit. And this court's cases just don't support that. I guess at this point, I'd like to turn to public policy, because another component of the litigation privilege, and I think it also does, as Justice Kruger, as you pointed out earlier, it does dovetail into kind of the enforceability and the limits of contract interpretation. Public policy here is squarely on Ms. Doe's side. As a very, very general, top-level matter, and I guess this would apply to both litigation privilege and contract interpretation, this court favors open access to judicial proceedings. As I mentioned at the outset, this court has said as much in probably about a dozen cases, certainly in 3 to 5 direct cases in the litigation privilege context. That policy right there should be enough to carry the day, because what Mr. Olson is trying to do, again, he's not trying to say that her suit is barred, but we're not looking at what effect Olson's counterclaim has on Ms. Doe. We're looking at what effect the rule that Olson is advocating for will have on the next Ms. Doe. My client happens to be very tenacious. She was not, chilled out of court, but the next litigant may be. Most litigants who go into civil harassment restraining orders are pro se, and there's a shockingly high number of them. As the Family Violence Appellate Project has laid out for the court, there is intimate partner, workplace, and other kinds of civil harassment and violence on the rise. There's a true epidemic of it. And as a result, those victims who go into, whether it's a family court seeking a domestic violence restraining order or a civil harassment restraining order, those victims go in to maintain the peace. And then if they're tenacious, like my client, they may go in and seek civil damages for the wrongs done to them. But if Mr. Olson's rule is adopted, the next Ms. Doe's will be deterred, because the prospect of large financial counterclaims for breach of contract could be financially ruinous to them. It's scary enough to go into court, not just once for the civil harassment restraining order, but twice for civil damages. And then to basically have your opponent say, well, I've got this poison pill so that if you lose, I can smack you with breach of contract damages. That will absolutely have a chilling effect. And that goes to the core of the litigation privilege. More narrowly, because we are talking about the context of harassment and violence, California absolutely has a very strong public policy in favor of granting more and more rights and remedies and access to victims and survivors of such abuse and harassment. Again, the Family Violence Appellate Project has laid it all out. I think they've canvassed over a dozen statutes just in the last 10 years where the legislature has recognized exactly what I just said, that California wants victims to have more access, more rights, more remedies, and not less. Most prominent.
Mr. Andre, before we run out of time, I wanted to get your take on CCP 1001. As your paper's notes, it was passed shortly before the petition here was filed. Does it, I mean, to summarize, does it take care of the problem that we granted review on? And if so, why is our intervention still necessary? If the legislature's taking care of it, do we need a common law remedy as well?
Well, I mean, I don't know about 1000. Well, I don't know about 1001. Certainly 1670.11, which is the statute that came the following year, right? So 1001 is the statute that prohibits effectively gag clauses. 1670.11 is the following year statute that nullifies or voids past gag clauses. 1670.11 is certainly not retroactive in my view, because the statute leads with any contract entered after January 1, 2019. I honestly don't know about 1001. It certainly doesn't resolve this case, because this case arose before 1001. Prospectively, it may mean that the issue is of diminishing importance, because after Jan 1, 2019, there may not be another case just like this. Although the court's intervention, given that the court still is, I assume the court was primarily interested in this case and granted the petition because of the litigation privilege issue. And there does need to be some clarification, in my view, brought to the scope of the litigation privilege as applied to breach of contract claims for the reasons I explained. I mean, Olson is advocating for a bright line rule that the litigation privilege does not apply at all to any species of breach of contract claim. And again, that would require this court to overrule, at minimum, Vivian, McNair, and Feldman, and arguably a handful of other cases that repeat what those cases said in dicta. And on the other hand, you have Wentland. And Wentland, in our view, is perfectly distinguishable. And so if the court were to pursue this case and adopt our rule, then, again, I think the court can actually affirm every published decision of the Court of Appeal that's on the books under the litigation privilege, and then lay out the limits so future litigants, whether in the civil harassment restraining order context or in the business-to-business context, where you have sophisticated represented parties negotiating the sale of a business, covenants not to compete, labor and employment agreements, so on and so forth, that those parties will then know exactly what is required to waive a party's ability to go into court and seek civil redress. And so, yeah, to answer your question, Justice Rubin, I think for the next CHRO case, or DVR, sorry, domestic violence restraining order case, 1001 may solve the question, may solve the issue, but for the broader question of how far does the litigation privilege reach into breach of contract claims, I think this court's continued intervention is necessary. I see that I'm just about up to my rebuttal time, so if the court has no further questions, I'm happy to yield to Mr. Kennedy.
Thank you, Mr. Andre.
Thank you.
Mr. Kennedy.
Thank you, Your Honors. Good morning. May it please the Court. Eric Kennedy on behalf of Curtis Olson. Doe's test assumes that the litigation privilege applies and that Olson has to prove that it doesn't. There's no legal precedent for this assumption, and it's inconsistent with how privilege law works generally. Olson's formulation of the test, on the other hand, is a direct quote from a recent lower court case, the Crossroads case, which merely represents an articulation of the rule as previously adopted in the Wentland line of cases. Olson proposes that we follow the Wentland line of cases, which establishes a rule that the litigation privilege will apply to contract claims only if the agreement does not clearly prohibit the challenged conduct and if applying the privilege furthers the policies underlying the privilege. The Court of Appeal got it right when it decided that Olson could sue Doe for breaching their settlement agreement because, consistent with precedent, Doe had voluntarily agreed not to disparage him. As is typical when invoking a privilege, Doe bears the burden to establish its application, but she can't do that. She can't satisfy these foregoing elements. First, she has not shown that the non-disparagement provision does not clearly prohibit her conduct. The non-disparagement provision at issue here is simple and straightforward. The parties agreed not to disparage one another for a period of 3 years. At the very least, the issue of what the parties intended in terms of the non-disparagement agreement is an issue of fact. It should not be resolved at the pleading stage via vehicle of an anti-SLAPP motion. Due process concerns support allowing Olson's breach of contract claim to proceed. Second, Doe has not shown that applying the litigation privilege to bar Olson's contract claim would further its underlying policies. As the Court of Appeal found, when someone is contracted not to speak, applying the litigation privilege does not support free access to courts and frustrates the purpose of the contract by immunizing the breach. Along these lines, the Wentland Court previously and relevantly noted that because a contract claim is not ultimately based on defendant's litigation conduct, but rather on a breach of an independent promise, a contract claim does not inherently undermine access to courts, truthful testimony, or zealous advocacy, which the litigation privilege is concerned about. Applying the privilege to a contractual non-disparagement agreement undermines the purpose of the contract, the policy in favor of enforcing private agreements. Doe argues that but for an absolute privilege to sue Olson, she would have no recourse for her alleged harms. That is, no way to sue for civil damages. In other words, she argues she would not have access to court. But that is not what the contract says. Doe was prohibited from disparaging Olson. He was not prohibited from suing him.
Let me stop you there. I just want to make sure I understand that argument. Are you essentially arguing that Ms. Doe could go ahead and sue, she could prove at trial that she was sexually assaulted by Mr. Olson, but that any recovery would essentially be offset by the reputational harm attendant to truthfully reporting and litigating the sexual assault? Is that the argument?
Mr. Olson is not seeking damages relating to reputational harm. He's seeking economic damages that arise from the breach of contract associated with the harm to his business prospect.
So, but it would work as an offset. But it would work fine. But it would work as an offset, right? So she could, again, she could prove at trial that she was sexually assaulted. And your argument is, but Mr. Olson would be able to say, but you violated the non-disparagement clause by proving, in this case, at trial, that you were sexually assaulted. So I also get damages for you having truthfully litigated the sexual assault. Do I misunderstand the argument?
You don't, but the tort damages would overwhelm, to a large degree, any contract damages Mr. Olson would get.
I'm sorry, say that again?
The tort damages would overwhelm the contract damages. So the contract damages wouldn't have...
damages, you mean what?
Mrs. Olson's award for proving would overwhelm whatever award Ms. Doe's award for proving would overwhelm any award Mr. Olson would receive for proving breach of contract.
Why?
I think that's the nature of the claims. For the tort damages that are sought, there include often emotional damages, other related harm, and including punitive damage. Mr. Olson's claim is related specifically to economic interest.
But what if he, again, we're writing with a broad brush, not Mr. Olson. Under your theory, if his economic damages were because of the reputational harm of a counterparty learning that it was alleged or proven that he'd sexually assaulted someone, he lost a highly lucrative contract to redo the Staples Center, then under that scenario, a plaintiff could successfully prove sexual assault, and if the counterparty happens to have big contract damages, the victim of sexual assault would end up owing the other side money because he's got big contract damages, right?
Well, both sides contracted for the ability to move forward with their claims. Whether or not there would be an offset that would be in favor of Mr. Olson or in favor of Doe, Mr. Olson should be allowed to proceed with his breach of contract claims based on what the parties voluntarily agreed to.
But just so I understand, you're not arguing that there'd be any sort of cap on the potential scope of economic damages by the counterparty. So we agree that maybe not in this case, but we agree you are articulating a rule whereby a party could successfully prove she was sexually assaulted, and because the truthful reporting of that violated the non-disparagement clause and caused economic damages to the other side, the victim of the sexual assault, as the result of litigating that issue, could end up owing the other side money. Isn't that the natural inference of your argument?
Yeah, and I agree that this is your illustration probably points out that the facts of this case maybe are not the right facts for addressing that issue, because what we have here, in addition to the contrast that you develop, is allegations against Mr. Olson that have since been proven false. After the settlement agreement, the parties engaged in a hearing, a several-day hearing, based on Ms. Doe's 2017.
Mr. Kennedy, why does truth or falsity matter? And I want you had a statement that Mr. Andre reported, which is, you say in your pleadings, if a Doe shoots and misses, then she might be in trouble economically. But isn't disparagement, as it's been interpreted by the courts and it's used in common parlance, such as in Provost versus Regents of the University of California, simply means speaking slightingly or negatively about somebody? It has nothing to do with truth or falsity. So isn't your theory of the case, as Justice Gropin is asking you, not if Doe shoots and misses, but if Doe shoots, she's liable? That's your interpretation of this agreement, correct?
Our interpretation of the agreement is that it's not based on truth or falsity to the extent that Doe is trying to characterize this contract claim as a cloaked claim for a tort. So this is a pure breach of contract claim. And so the concerns that might arise in the context of applying the litigation privilege from a policy perspective don't arise in this case because we're dealing with pure contract issues, which illustrates the fundamental difference, a fundamental difference between the parties' arguments, and brings us really to one of the court's second issue, at least a portion of the court's second issue, which is whether or not the mediated agreement between the parties in an action for a temporary restraining order in which they agree not to disparage each other bars an unlimited civil lawsuit arising from the same alleged sexual violence. And we argue that it doesn't for at least two reasons. The litigation privilege should not apply to a contract claim involving breach of a non-disparagement agreement where the action is filed in a manner calculated to prevent the disclosure of the accused, and also for issues concerned with fairness and equity. And the Court of Appeals holding recognizes this. Allowing the parties to pursue their claims in parallel, Doe can still sue, she just can't disparage Olson. For Olson, the parties can both bring claims. For Doe, only she can. And that's not fair. That's not what the law requires, and that's not what the parties agreed to. Doe and the amici justify this treatment of Olson by accusing him of sexually assaulting Doe. Olson has denied all of these allegations, and as I mentioned, they were proven false after a several-day hearing with 14 witnesses, in which Doe was represented by counsel. Olson should not lose his right to enforce a voluntary agreement due to the nature of unproven allegations against him.
Mr. Kennedy, in that parallel proceeding, if it were to proceed, if this case were to resolve that way, could she also amend her pleading to sue him for breach of contract of the non-disparagement clause? He's calling her a liar. Doesn't she also get contract damages for that?
She could, but she's named pseudonymously in this case. And so the disparagement would not be the issue, and that's the issue for Mr. Olson. Had Doe named him under a pseudonym or filed her complaint under seal, then we wouldn't have this claim because the disparagement would not be at issue. She chose not to do that. She was obviously aware of that process and procedure. She did it herself, naming herself under a pseudonym. But the bell can't be unrung at this point. She's already sued him using his name.
Mr. Kennedy, I would like to ask you the same question I asked your friend on the other side, which just has to do with clarifying the relationship between the two components of your argument, the litigation privilege argument and the contract interpretation argument. As I hear you today and as I understand your briefing, those two things also overlap for you, for your position, because as I understand it, your argument is not that the litigation privilege never applies to any sort of breach of contract claim whatsoever, but rather it doesn't apply where the parties have agreed that it shouldn't apply. And the question is whether the non-disparagement clause in this case should be understood as a waiver of the litigation privilege or not. Your friend on the other side says we should presume that it isn't, and your argument is sort of to the contrary, that we should read the language on its face to encompass all forms of disparagement, including disparagement in the form of filing a lawsuit. Is that an accurate summary of your position, or is there...
Yeah, that is an accurate summary, and I'll mention two things in connection with that. This disparagement clause or non-disparagement clause is obviously very different than the non-disparagement clause that was mentioned in Vivian. There were certain exclusions that applied, and there the parties could not disparage. They could not make disparaging comments to another party. And it seemed like the Vivian court wrestled with the ambiguity that was created by the various exclusions that applied in that non-disparagement provision, which simply don't apply here. And I think that's why, to address something that Mr. Andre said, it was easy for the Court of Appeals below to draw a distinction between Vivian and Wentland and find that Vivian applied to the extent of Ms. Olson's administrative claims, but didn't apply to the extent of her contract claims. And that's why we think the Wentland case makes this court's path clear to finding that it doesn't apply to the contract claims that are at issue here, because of the distinction between the policies that were at issue as between Wentland and Vivian. So we do believe that there is a difference. We do believe that the disparagement provision that was at issue in Vivian is significantly different, and we do think it makes sense that the distinction that the Court of Appeal drew, allowing for Mr. Olson's contract claim to proceed and not allowing for the claim, at least as it related to the civil damages complaint, and not allowing it for proceed as it related to the administrative aspects of Ms. Doe's actions.
Mr. Kennedy, could I ask you about just a slightly different aspect, which is it correct that you don't disagree that Ms. Doe could seek a renewed application for a restraining order, in essence, a further Section 527.6 petition, which she in fact did file? That's not barred by the non-disparagement clause.
It's not barred.
Why is that?
For the same reason that it wouldn't be barred under the Vivian or Wentland hold. That is different in nature and both purpose and outcome from seeking civil damages through a traditional complaint lodged in Superior Court.
Is it because it's not disparagement?
No, the process and the outcome in the civil harassment restraining order context is not seeking civil damages. It's seeking some sort of redress for alleged harm. So there's an investigation that's conducted, not totally unlike investigations that were conducted in the Vivian case and in other cases, where the distinction is drawn between administrative agency or a governmental authority seeking to pursue alleged wrongdoing as opposed to civil damages.
I guess well, that's true, but I guess I'm wondering where that is. You're sort of drawing a distinction, but where does the distinction come from? If it's based in the contract, why is one disparagement and the other not?
It's not the issue of disparagement. It's the issue of the enforcement. So the lower court decided that you couldn't enforce Olson could not enforce his contract claim as it related to that type of an investigation, which would be similar to the type of an investigation, or at least remedies sought in the civil harassment restraining order context. You asked whether she could pursue that in the civil harassment restraining order context, and the answer is yes, under Vivian, Wentland, and this court, the lower court's decision.
So if Ms. Doe were to do a third party, not Mr. Olson, but in the process make similar statements with respect to Mr. Olson, or if she didn't even sue anyone, if she was called as a witness in someone else's lawsuit and made similar statements with respect to Mr. Olson, would she be in breach?
Yes, she would. The non-disparagement provision prohibits her from disparaging Mr. Olson. If she was called to serve as a witness testifying in another case that somehow related to Mr. Olson to the extent she needed to testify about Mr. Olson, there are processes in place where she could do that without disparaging him in the context of using confidential proceedings or some other aspect of anonymity that would be available to him.
Even how far are you willing to go with this? Criminal trial, that would still be true?
No, I think criminal trials are different. Although it is true that we don't necessarily limit it to criminal trials. I mean, there's obviously remedies for perjury, and there's remedies for false statements made in criminal trials as well. But that's not what the case we're dealing with here. I mean, we're dealing with a situation where the parties negotiated, and as Ms. Doe has indicated, negotiated with the help of a mediator who was explaining to her along the way the different aspects of the settlement agreement. She has not said that she didn't understand what non-disparagement was. She has made other claims about the process for entering into the settlement agreement and how it may not have been fair to her, but she had a mediator there that was walking her through the process. She entered into the agreement. The parties were done at that point. Shortly thereafter, she files a civil lawsuit against Mr. Olson alleging the same allegations. Mr. Olson merely seeks the opportunity to pursue the claim to show that he had already bargained for some finality here. So in this case, applying the litigation privilege actually fosters additional litigation over issues that the parties already decided.
Mr. Kennedy, may I ask you a question about how this case arose? Settlement agreement arose, as we all know, out of the expedited injunctive relief provided by 527.6. It's already been mentioned that 527.6 has a subsection W that basically tells a plaintiff in a hearing such as this or in a process such as this that they have to go elsewhere to get any relief that's non-injunctive. And here, your position, as I understand it, is this disparagement clause in the mediated settlement agreement waived that right. Is that correct?
That is not our position. Thank you for. Our position is not that she waived the right to go somewhere else. Our position is that she waived the right to disparage Mr. Olson. She could go somewhere else and seek relief. She just doesn't she can't name Mr. Olson using his name because that's what creates the disparagement. Had she sued him somewhere else as Mr. Doe or Mr. Rowe or something like that, we wouldn't be having this conversation. Because she still has that right, as you identified, and we are not arguing that she waived the right to sue. And that's the fundamental flaw in Ms. Doe's argument, is that we are claiming she waived the right to sue, which is not what we have claimed.
Thank you.
To conclude and to address an issue Mr. Andre raised, we do argue in this case that as an issue of first impression, that this court should issue a bright line rule establishing that the litigation privilege does not apply to contract claims for several reasons. And this really is to address the presumption that Ms. Doe argues for in favor of applying in favor of applying the litigation privilege to contract claims, because that rule ignores the nature of contract claims, contravenes fundamental public policy in favor of freedom of contract, and does not advance the main purpose of the litigation privilege. So we urge a bright line standard. Contract claims do not implicate the primary policy of the litigation privilege. That is the first point. The legislature originally implemented the litigation privilege to limit liability for tort of defamation. The main underlying policy was providing freedom of access to courts without fear of harassment for derivative tort liability. There is no fear of harassment for derivative tort liability inherent with the contract claim by virtue of the nature of contract law. Contract law exists to enforce the intentions of the contracting parties. A potential breach of contract claim cannot cause a litigant to fear harassment by derivative tort liability. As the Wentland Court held, when a party voluntarily contracts not to sue or otherwise speak in court, a claim for breaching that agreement does not limit the party's access to court, and thus the policies underlying the litigation privilege are not impacted. Second, a contract claim is not just an artfully pled defamation claim, as Doe suggests. This court expanded the litigation privilege to other torts, so the artifice of suing under a convenient different label could not circumvent the privilege. But no such risks exist in contract claims. A plaintiff trying to avoid an anti-SLAPP motion attacking its torts claims cannot simply bring a contract claim. The contract has to exist. Moreover, Olson's breach of contract hinges not on whether the speech is true or false, but as we discussed, but on Doe's breach of an independent promise not to speak. Defamation, the tort, on the other hand, is fundamentally about falsity. And as we have discussed, the damages sought under the paradigms are fundamentally different. Third, to the extent there is any perceived risk a litigant might attempt to bring a frivolous contract claim to harass another litigant, the second prong of the anti-SLAPP statute mitigates against this risk, if not eliminating it altogether. California's fundamental public policies favoring freedom of contract weigh against applying the litigation privilege to contract claims. Indeed, applying the litigation privilege to a contract claim would impair the policy and immunize defendants from enforcement of agreement freely entered into. For all these reasons, and those discussed in our briefing, unless the court has additional questions, my presentation is done.
Thank you, Mr. Kennedy. Mr. Andre?
Thank you. Just a handful of points here with the time remaining. We don't dispute that the freedom to contract is important and that California, all states recognize that it's important. But the freedom to contract only goes so far as the contract itself goes. And so that is why the best way to analyze the litigation privilege and also the litigation privilege issue and also the mediation stay away agreement here is by looking at what exactly did Ms. Doe waive by entering into it. And just saying that contracts are important and that the state favors parties' ability to freely enter into them doesn't answer the question of what exactly did Ms. Doe and Mr. Olson agree to. Mr. Kennedy concedes that here, or he argues that here Ms. Doe owes damages simply by the act of publicly filing a suit and naming him. That is precisely why, in the absence of clear and explicit waiver language in the mediated stay away agreement, the litigation privilege must bar his counterclaim. The fact that Ms. Doe may, or Mr. Kennedy's argument that Ms. Doe may owe damages, whether small business-related economic damages, which I agree Justice Groban may actually be astronomical in light of the nature of Mr. Olson's business, or large reputational damages like the $4 million reputational harm award that we cited in our reply brief. Either way, the specter of monetary damages based on Ms. Doe's act of filing a suit strikes right at the core of the litigation privilege because it is so chilling. I want to address next Mr. Kennedy's argument that both sides contracted to proceed with their respective claims in parallel. That is, as we explained in our reply brief, it's creative, but it's a total reimagination of the record and the procedural history of this case. Mr. Olson's position, up until he got to this court, was that specific performance required the dismissal of Ms. Doe's administrative complaints and her civil complaint. In other words, his position up until the Court of Appeal ruled was that she had no right to be here. Now that the Court of Appeal has said that the administrative claims are out, but the breach of contract civil claim for damages proceeds, and yet his specific performance claim is also out, now Mr. Olson says, well, of course, then this means that the parties contracted for their claims to proceed in parallel for damages. But that is not the position he has taken. And incidentally, the reason why the specific performance claim is out is not because the Court of Appeal found that the litigation privilege did not apply to it. The Court of Appeal found that the litigation privilege did not bar it. But then the Court of Appeal went on to say that Olson effectively waived his challenge to the trial court's ruling on it under the second minimal merit prong of the anti-SLAPP statute because he only had 2 sentences of argument trying to explain why the Superior Court may have been wrong. So again, his position that the parties somehow contracted to allow these damages claims to proceed in parallel is a total reimagination of the position he's taken throughout this litigation. And, again, it's clever, but it's based simply on kind of the fortuity of how things played out in the Court of Appeal, but it is not the way that the litigation was originally conceived. And I think that the court needs to analyze this issue based on how the parties each stepped into the Superior Court with their respective claims. Because, again, litigation privilege is focused on chilling effects, and the contract interpretation analysis that I've advocated for looks at what exactly can Doe do when she steps into court in the first instance. I next want to address Mr. Kennedy's assertion that Ms. Doe's claims have since been proven false. That, frankly, is a shameless mischaracterization of the record. If the court looks at the request for judicial notice that Mr. Kennedy and Mr. Olson filed just 2 weeks ago, to particular page 37 of the RJN documents, Judge Convey was clear that in the second civil harassment restraining order proceedings, everything that predated the mediated stay-away agreement was out. He said, I'm not going to litigate that. I'm not going to touch that. You had this agreement. We are just talking about December 2015 moving forward. So with respect to the allegations that were before the CHRO court in the first proceeding and that underlie the majority of Ms. Doe's allegations in the civil complaint before this court, those allegations were not considered by Judge Convey in the second CHRO proceedings, and therefore Mr. Olson has not been exonerated with respect to them. Finally, I guess I'll wrap up with Mr. Olson's position that somehow the disparaging act by Ms. Doe was naming him publicly by name as opposed to using a pseudonym. Again, it's a clever argument, and we have no problem with Mr. Olson proceeding under a pseudonym. The problem is that Mr. Olson's argument is not only doubly forfeited, it's affirmatively waived. It's doubly forfeited because Mr. Olson did not make that assertion in Superior Court. He did not make that argument before the Court of Appeal. And in fact, if the court looks at page 78 of the appendix, Ms. Doe declared that she specifically told Olson, recommended to him, that he either move to redact his name, proceed under a pseudonym, or move to seal the proceedings, and that she would not object. For whatever reason, Mr. Olson chose not to do so. So for him to now come here and say that somehow the construction of the litigation privilege or the interpretation of this contract turns on the fact that Doe named him publicly when she was perfectly willing to let him proceed under a pseudonym just cannot possibly carry the day. Finally, with respect to Mr. Kennedy's argument that somehow the parties understood, based on what the mediator told them or based on the nature of the proceedings, that they could proceed in parallel, that also is belied by the record. If you look at the appendix, page 80, Ms. Doe declared as to what the mediator told both parties at the outset of the mediation, and what the mediator told the parties is consistent with what I mentioned in the opening argument, that all of the forms, the mediation agreement itself and the statute itself, all indicate that if you want to seek civil damages and other remedies, you have to pursue them in other proceedings. And so contrary to Mr. Kennedy's argument, the mediator said that to the parties. And the mediator amici that have supported us have also said that that is how they train mediators to advise parties when they walk into a civil harassment restraining order mediation. I see I'm just about up with my time, and so unless the court has any questions, I'm happy to yield a few seconds back to the court.
Thank you, Mr. Andre. Thank you, Mr. Kennedy. Matter submitted.